morning. I am Professor Constance Anastapoulo. I'm an associate professor at the Charleston School of Law, and we are here today to talk about ethical traps to avoid hot button issues. So thank you for being here, and we'll get started. To talk a little bit about my experience, so I was a litigator for 15 years. I have been a professor at the Charleston School of Law now for 8 years, and I teach torts, insurance, and professional responsibility. So I'm going to talk today, as I said, about some of the hot button issues and just talk a little bit, share with you some of my experiences in class with my students, as well as some of my experience from actually practicing law. So one of the probably the biggest area where lawyers get in trouble, young lawyers, old lawyers, people have been around a while, is money. So we talk about money, money, money. And where do lawyers put, transfer, keep money? That's in their trust accounts. So let's start a little bit with some of the problem areas that arise in trust accounts and trust account accounting. So one of the first things is the attorney takes the money before it is earned. So we're going to talk a little bit about when is it earned, because that becomes a problem. A lot of lawyers will take a fee, and we're going to talk about fees as well today. Take a fee, put it in their trust account, and then they pay themselves out of that trust account. And when they do that, that's fine as long as the fee has been earned. And so sometimes they take fees when they haven't been earned, and that's when they get in trouble. Second area is the attorney makes a math error, right? Sounds simple. And that causes a negative balance to occur in a trust account. If a trust account has a negative balance, if a check bounces in a trust account, it is automatic that the borrower will come and look and find out what's going on, because that is a prima facie evidence that there's a problem. So, because again, that money is being held in trust, there should always be money there to have accounting for it. So if there's a negative balance in a trust account, something bad has happened, and that's not good. All right. The third thing is trust account theft. Right? And it's not, occasionally it is the lawyer, but oftentimes it is the person in charge of the trust account, the trusted employee. So we're going to talk a little bit about that as well. Okay. So let's start with when is a fee earned, right? When is a fee earned? So attorney can disperse money from the trust account to him or herself once the fee is earned. Well, Model Rule 1.16D said any advance payment of a fee or expense that has not been earned or incurred must be refunded upon termination of employment, right? So again, that sounds so simple, but in practice, it gets complicated. So you've been working on a case, you've been working on the file, you've got some expenses in it, you've got some hours in it, and then the client terminates the fee. Who decides how much of that money is refunded? How much of it has been earned, how much is allocated to expenses, and that's where the trouble starts. So the model rule also says no fee that has not been earned may be kept after termination. And again, sometimes lawyers account for hours that they think they're going to put in, or they know they're getting ready to put in, and that fee has not been earned, and that fee has to be returned to the client upon termination. So it's kind of a gray area. When is the fee earned? Is it when the hour is over, when the hour is started? It gets complicated, and that's an area of potential trouble for attorneys. Okay, so let's talk a little bit about the different kinds of fees that are available. And I'm sure you're familiar with most of these, but let's start with a flat fee. Why is a flat fee so attractive? Well, it's attractive to both sides, the client as well as the attorney. So for the client, it provides certainty as to the cost. I'm going to do your divorce for $5,000. And if it takes me 1 hour or 20 hours, it's going to be $5,000. That's a flat fee. It provides certainty to the attorney, but it's a little risky for the attorney too, unless the case is kind of a cookie cutter kind of case that the work can be delegated. Let's say it's a closing for real estate, for a house. That's a pretty cookie cutter case, right? So you have an assistant, that assistant knows how to draft the documents, how to pull the title, how to do the title search, how to get the title insurance. And it's pretty much the same thing over and over again. So that's a good example of something that's a cookie cutter kind of legal problem. It can be delegated to an employee. The attorney oversees that employee, but they know pretty much what the hour is going to, or how many hours it's going to take to do that. So that's a good place for a flat fee. As I said, it's a little risky to the attorney if complications arise, because they don't get necessarily paid once they have that flat fee established, or if the case is terminated before completion, right? Again, we've got the problem of when is a fee earned. So if you have a flat fee, let's say it's a divorce, a $5,000 divorce flat fee, and the client gets dissatisfied with the attorney halfway through and says, I'm done, is the flat fee earned or is it not earned? And that's a complicating factor. I looked a little bit at some other states, and one is the California rule, which I like because it's in writing. And it says that the flat fee agreement must be in writing. It is the attorney's property upon receipt, if it's in writing. And it includes the scope of services, the total amount of fee. The fee is the attorney's property, but the client can still terminate the arrangement. But it delineates who has the fee, who owns the fee. So once the client pays that fee, and if the client terminates before the case is complete, in most cases the attorney can keep that if they have designated it in writing, made it clear and unequivocal to the client what the circumstances are going to be. Now, there is a subcategory in the California rule that does allow the client to get some of the feedback. Let's say you hire them on Monday and you fire them on Tuesday, right? Do you lose your $5,000? And so there is a provision within the California rule that allows the client to say, hey, you really didn't earn any of it because I fired you the next day. But for the most part, if it's in writing, the attorney can keep the fee. So I like that clarity. And again, that's kind of what causes problems for attorneys when we're dealing with flat fee, is that the termination occurs prior to the conclusion of the legal issue. Okay, so that's flat fees. The other fee that's pretty common is hourly fees, right? And hourly fees are great because the attorney gets paid for every hour they put into the case. And that's really nice. The problem is, what is a reasonable flat fee? So the model rule 1.5 says the fee in an hourly case must be reasonable. Now, who determines what's reasonable? Well, the bar will look at a couple of different factors that go into the reasonableness of an hourly fee. So I've seen everything from $95 an hour to $1,500 an hour. That's not unreasonable if you look at the factors that go into it. So some of the factors that are considered in determining whether or not an hourly fee is reasonable is the time and labor required, the skill required, what is a customary hourly fee in a situation like this, time limitations, the novelty and difficulty of the question, right? If you've got a case that's going to the U.S. Supreme Court, that's usually pretty novel and pretty complicated. The preclusion of other work, right? If I take your case, I'm not going to be able to take these 3 other cases. So I have to charge an hourly fee that is going to compensate me sufficiently because I'm going to exclude other work. And then lastly is the amount involved and the results obtained. Is it the kind of case that this lawyer can be successful doing, right? So those are all things that go into determining whether or not an hourly fee is reasonable. So when we think about hourly fees and the relationship with the client, it must be explained to the client the basis of the rate and how the expenses are going to be calculated, right? So does the hourly fee just compensate the attorney, and then there's going to be an additional amount associated with the expenses? And we're going to talk a little bit about what expenses can be passed on to the client and what expenses cannot be passed on to the client, right? Hourly fees, preferably in writing. I would say always in writing. You and we're going to talk a little bit more about fee agreements. And again, that's an area that tends to be a problem, hot button issue is the agreement between the attorney and the client, particularly with regard to fees. All right. Uh, Preferably in writing, and that writing should happen before the attorney takes the case or within a reasonable time of taking the case. And then there's an exception to that where you have a client that you regularly represent. So let's say you have a client that you do continuing work for. They bring an issue, you handle it. They bring something in the same general area, you handle it. You don't have to keep writing a new fee agreement every time. You can rely back on your prior fee agreement. But that's generally an exception. For the most part, it should be done before you engage with the client or within a reasonable time, and it should be in writing. And you have to explain how the fee is calculated, the basis of the fee, and how expenses will be handled. All right. So, as I mentioned, when we talk about expenses, there are certain things that cannot be passed on to the client. What's not an hourly fee, right? So you can't pass on general office expenses and overhead, things like the lights, the rent. Those are things that cannot be passed on to the client, general office and overhead expenses, right? Payments, the law requires the opposing party to pay. For example, they may, the other side may be ordered to pay attorney's fees. Those belong to the client. Those are not the attorney's. They can be credited to the client, but those belong to the client. And then thirdly, when a lawyer requests and receives a fee not for services already rendered, those belong to the client as well. So those are three kinds of fees that are not, or expenses that cannot be considered hourly, cannot be passed on to the client, or they belong to the client as a matter of law. Okay. Any questions, guys? Nope. Good. Okay. Okay, and then the third kind of common type of fee, and a lot of personal injury cases take a contingent fee, the contingent fee. And that is a percentage of the recovery, the contingent fee. So again, it should be in writing. It should be explained to the client. And the big issue, I think, with contingent fee agreements primarily is how do you deal with expenses? Do they come off before before the attorney calculates his percentage, after the attorney calculates his percentage? There's no right or wrong to that, but it has to be explained to the client. Okay, it has to be explained to the client. So contingent fees are not permitted in some kinds of cases. So they are not permitted in domestic relations cases generally. You can't have a contingent fee contingent on me getting a divorce for you, or contingent on me getting your custody of your child. That would be improper and impermissible under the rules. You can have a contingent fee when you are representing someone to collect back child support or back alimony. You can say, if I can get you this much child support back, I can take a percentage of that. But that's an exception to the rule that contingent fees are not permissible in domestic relations cases. Contingent fees are not permissible in criminal cases, right? You can't say, if I keep you out of jail, I want a percentage. And they must be informed consent and in writing, right? Informed consent and in writing. So I would tell you every fee should be informed consent in writing. But particularly with contingent fees, it's a requirement that they're in writing. And again, the more information you give to the client about that and the more information you put in the fee agreement, it is one of the best tools that attorneys have to protect themselves. Okay. All right. So some of the best practices, as I just mentioned, some of the best practices when it comes to fees, right, is fee agreement in writing. As I said, how do you protect yourself? Say, well, you signed this, here's the document, and here's what it says. So the document, your fee agreement should be a living document. It should be updated regularly. As things change in your office, as your practice evolves, you should continually update that. I think when I started practicing back in the dark ages, our fee agreement was 2 pages. Now at the firm where I used to practice, I think it's 20, because we have continued to add and build in more and more information for the client that is protection for the attorneys, really. So again, it's a living document. It should be continually updated and added to. And it is the best tool when there's a fee dispute. Because if the client says, well, I didn't know the expenses were coming out before or after the attorney took their contingent fee, all you have to do is point to the document. Right here it says, and done. So it is the best tool to protect an attorney in a fee dispute if you have it laid out as clearly and unequivocally as possible. And again, I think our fee agreement's 20 or 25 pages, something like that. Okay. All right. So we've talked a lot about fees. So the next question is, how do you collect the fee? That's another area where attorneys can get in trouble, right? They've done the work, but they haven't been paid. How do they get the fee? And this comes up again sometimes in a lot in domestic cases where you go in, you think that the divorce is going to be fairly simple, you get into it, you charge an upfront retainer, the client burns through that retainer because they're calling you 3-4 times a day, burns through that retainer, and it's a lot more involved than you think it's going to be. What do? You've got more and more and more hours, and now the divorce is coming to a conclusion and you haven't been paid. How do you get your fees, collecting those fees? All right. Here's what you cannot do, right? Here's what you cannot do. You cannot employ methods that are forbidden by law. You can't send some heavy security guys down there to rough up your client, obviously. But you cannot employ methods forbidden by law. You cannot use confidential information to collect that fee, and you cannot harass the client, right? So what is harassing the client? It's a pretty bright line when you cross that. You can send them letters, but can you call them, have like collection agency call them? You cannot. That's harassing the client. So you cannot harass the client. So you can't use methods forbidden by law. You cannot use confidential information. Obviously, it's attorney-client, and you cannot harass the client. All right, so what can you do in collecting your fees? Well, you can adjudicate the issue before any appropriate proceeding, including suit for unpaid fees. So you can utilize the court system to collect those fees. You can use arbitration, to which both parties consent unless the law renders the attorney's consent unnecessary. In other words, it might be that the client is wanting to arbitrate some fees back, and the attorney does not have to consent to that, right? So you can use adjudication through the courts. You can use arbitration if both parties agree. The court, once you're in the court system, at the court's discretion, they can send the issue to some kind of ancillary proceeding, some kind of ancillary. So they might send it to a mediator, for example, to resolve the issue. And I think most importantly, it's not a very good idea to take your client to court to collect fees, but if you find yourself in that situation because you need to, the attorney has the burden of proof. The attorney has the burden of proof, all right? So you have to prove that you haven't been paid, that the fee's been earned, and whatever else you need to prove in order to be successful. So the attorney has the burden of proof in that situation. So those are things you can do that are permissible in terms of collecting fees. If you're smart, you never get to that point because you've explained it all in your attorney fee agreement with your client and everything is good. All right. So let's talk about fee agreements and retention, right? Fee agreements and retention. So as I mentioned earlier, some of the best practices when it comes to the fee agreement is don't use boilerplate fee agreements, right? You can pull it off the internet. You can go to Office Depot and say, oh, they've got fee agreements there. Don't use those. You need to formulate it based on your practice, your clients, the issues that come up. And again, it should be a living document that you continue to update and revise continually. It should clearly communicate things like expenses, as I mentioned. When are they taken out? Who pays for them? What's going to be included in those expenses? When are they calculated? The scope of the work that you're undertaking. So when I started practicing, as I said, we had a 2-page fee agreement, and it would be, let's say, a personal injury case. So the client would come in and I would write in the little blank space, we will represent you in the car wreck, right? And we're going to take this percentage. And then the client would sign it. Well, one of the things I found out pretty early on was we didn't really account for the appeal. Who's going to be responsible for that? Who's going to pay for that? Am I on the hook for that? Does that come out of the contingent fee? Is that a separate fee? Is that a separate contract with the client? So I learned pretty early on that I better account for the scope of the work. Here is what I am going to do. Here's what I'm not going to do. This fee agreement does not cover appellate work. It doesn't cover this, that, and the other thing. So again, that's something that you have to put in the fee agreement in order to protect yourself. Additionally, termination. Who can terminate? Can the attorney terminate the client? Or if the client becomes unmanageable, can the attorney terminate that? That's an issue that needs to be resolved in the fee agreement. Refunds, right? As I said earlier, if it's a flat fee, who owns that? If you have it covered, like the California rule, in writing, and you say when paid, it is received and the property of the attorney, then you have given the client informed the client as to refunds. And then particularly the amount of the fee. Is it going to be a contingency fee, flat fee, hourly rate? How is it going to be calculated? Very, very important. So the ABA Model Rule 1.5b says preferably in writing, but contingent fees must be in writing. And I would say, again, best practices have every fee agreement in writing, whether it's a flat fee, an hourly fee, or a contingent fee. Okay. Any questions so far? Nope. Okay. All right. So we've spent a lot of time talking about trust accounts, fees, fee agreements. Very, very important area. Again, where a hot button issue, where attorneys get in trouble, where clients file complaints with the Ethics Commission. So it's not usually my attorney's not good. It's my attorney didn't explain the fee to me, and now I think they've taken too much, or I didn't get my money back, or I didn't get enough money. Most of the complaints that are filed with the bar have to do with money, right? What other areas potentially are risks for attorneys and hot buttons? Well, the first one is conflicts of interest. Conflicts of interest, right? Where attorneys kind of sometimes get in trouble is that they have conflicts with current clients, right? So what constitutes a conflict with a current client? Well, it may be that you take two clients that had adverse interests, right? Adverse interests. You represent one client, you have another client, let's say it's a real estate matter, and all of a sudden you're representing two developers that potentially have interests that could be or are adverse. How do you deal with that? Well, absent consent, the attorney may not act as an advocate in one matter against a person the attorney represents in some other matter, even when the matters are wholly unrelated. In other words, you cannot take a position against or advocate in one matter against a client, even if they're completely separate from what you represent your client on. You can't advocate against a client, and that's really what it gets down to. You cannot advocate against a client, irrespective of the matters involved, right? You have a duty of loyalty to the current client. And I can't stress that enough, because attorneys think, well, they're completely unrelated. I represent him on X and I represent him on Y. That's not adverse interest. And again, if you keep in mind you have a duty of loyalty to the current client, you cannot take the new client if you're going to advocate against your client. All right. Consultation and consent. So Rule 407 of the South Carolina Appellate Court Rules say a communication of information reasonably sufficient to permit a client to appreciate the significance of the matter in question. Consultation and consent. So in my ethics class, and I think, Creighton, I had you in PR. So we talked about this in PR in my ethics class. So you're at a Christmas party, right? It's almost Christmas time. You're at a Christmas party, and your neighbor comes up to you and asks you and says, hey, I've got a new girlfriend. I think I want to split up with my wife. Do you think I should clean out my bank account? Right? terrible situation, and you say, I don't want to get involved. I don't want to get involved, right? Have you now been engaged for attorney-client purposes in terms of privilege, right? So a communication of information reasonably sufficient to permit the client to appreciate the significance of the matter in question. Have you engaged at all with that client? And I would caution you that potentially you have now received confidential information. The guy has told you he's got a girlfriend, right? That potentially is adultery. He's talking about clearing out a bank account. That's a potential problem if it's a joint asset. So you have to be very, very careful. Even if you say, well, I wasn't paid, right? I didn't have a fee agreement with the client. Have you engaged in an attorney-client relationship? And I would suggest that you have, and to take the precautionary step that potentially you have, and the information you receive. Can you go home and tell your wife or your husband after the party, oh my God, you won't believe what Jerry told me at the party? You can't do that because, again, that's privileged information. So you have to be very, very careful. All right. All right, consultation and consent. So as a little further development of this, consultation is more than just keeping the client updated. It means reasonably consult with the client about means to be used to carry out the client's objectives, right? And again, this is an area that if you look at complaints filed with the bar, this is an area that comes up again and again and again. The client says, I was not sufficiently updated. I didn't know he or she was going to do this, or I wanted them to do X, Y, and Z. And the attorney says, hey, I sent them letters. I said the case is progressing. I called them once a month. I said the case is progressing. That is not enough on the part of the attorney in terms of keeping the client informed and consulting with the client. And it has to be more than that. You have to discuss with the client the objectives of the case and the means used to carry out that objective. In other words, here's what we're going to do. We're going to depose X, Y, and Z. I think I'm going to file this motion. I'm going to try to do this. You have to keep the client more than, hey, I got it covered. Don't worry about it. I'll call you if there's a problem. That's not updating your client on the means necessary to carry out the client's objectives. You must keep the client informed of settlement offers. I cannot stress this one enough. So, again, in my practice, I used to represent a fair number of personal injury clients. And the adjuster would call me and say, we're offering X. And I wanted Y. And we were miles apart, right? And I knew my client was never going to take X. However, I had a duty to every client to tell them, you have received an offer of X. Even if I know the client's never going to take it, that doesn't matter. I cannot make that decision for my client. I have to inform the client of a settlement offer. Hey, the adjuster's offered X. What do you think? And the client would say to me, well, what do you think? And I'd say, well, based on X, Y, and Z, I don't think that's sufficient or whatever, but it's the client's decision. And so every settlement offer must be conveyed to the client. Conversely, right, on the other side of that car accident usually is an adjuster, an insurance company, and a tortfeasor. The tortfeasor is the client, and we're going to talk a little bit more about this, particularly in South Carolina, that's a one-client model. The tortfeasor is the client, and the defense attorney who's being paid by the insurance company has a duty to convey the settlement offer to the client. So oftentimes in an accident case, the attorney says, well, we'll settle for the policy limits. And the defense attorney says, we're going to litigate it, right? They have not conveyed the offer to the client. That must be done. That attorney has to pick up the phone, call the tortfeasor, the insured, and say, hey, we have received an offer of settlement for X. What do you want me to do? Very, very important. And it does, I'm not sure it happens in every case. And that's very important. Okay. And so one of the other things about consultation and consent is that the attorney can be potentially liable for negligent advice. That's kind of scary if you think about it, right? What is negligence? At least in this state, it's what's reasonable, what's not reasonable, right? So again, back to the car accident situation. If the damages in the tort for the tort fees are $1,000,000 and the policy limits are 25,000, and the plaintiff offers to settle for the policy limits, and the attorney doesn't pick up the phone and call the insured and say, "Hey, your exposure is potentially $1,000,000. You've got 25,000 in coverage. Do you want to settle the case?" And the client says, "I don't really know what to do. What should I do?" And the attorney says, "Hey, let's roll the dice," right? That potentially puts the attorney at risk for negligent advice. Because of the situation, that the exposure to the client's $1,000,000, they have coverage for 25,000. They should just pay the policy limits. So again, that's kind of a tricky area for attorneys, that they potentially can be held liable if their advice is negligent. Got to be reasonable. And again, that goes under consultation and consent. Okay. All right. So we talked a little bit about conflicts with current clients. Let's talk about conflicts with former clients, right? If you've been in practice as long as I have, which is a long time, if you've been in practice as long as I have, you've represented a lot of people, and there are a lot of former clients out there, right? How do you protect conflicts with former clients, right? So Rule 1.9 says a former client must be given informed consent confirmed in writing when he or she undertakes to represent another person in the same or substantially related matter adverse to the former clients, right? Adverse to the former clients. So again, it must be in writing, informed consent confirmed in writing to the former client. So let's talk about a real estate situation again. So you represented a developer in getting permitting for an office building, right? Several years pass, and now one of the tenants in the office building wants to sue over the way that the building was built and the permitting associated with it, right? So they are substantially related matters. Former client, before you take that tenant, you have to get informed consent confirmed in writing from the former client that you are now going to take a position adverse to your former client. Even though you don't represent the guy, hadn't seen him in 10 years, that is still a former client, and the rules require, before you take the new tenant as a client, you have informed consent confirmed in writing. All right, so, and that doesn't change irrespective of how much time passes. All right, conflicts again with former clients. Rule 1.9 says the lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm attorney was formerly associated or had previously represented the client, right? So the days of the solo practitioner are, I think, getting smaller and smaller, and there are firms, more and more groups of firms, and that's what we're talking about here. So one of the push and the pull when it comes to former clients and firms is that lawyers change firms a lot too, and we're going to talk about that. When is it so restrictive in regard to a former client that the attorney is kind of penned in changing firms? Let's say it's a really mega firm, one of the bigger firms that have multi-state offices. Who's a client of that office? And we're going to talk a little bit about that. So again, a lawyer shall not knowingly represent a person in a same or substantially related matter in which the firm attorney was formerly associated and had previously represented the client. So when your firm represents someone, that potentially is a former client of yours. And again, depending on the access to the information, and we're going to talk a little bit more about that. All right, so how do we break down Rule 1.9? Well, we talk about whose interests are materially adverse to that person, right? So you're taking on a new client whose interests are materially adverse to a former client or former client of your former firm or your firm. And secondly, about whom the lawyer had acquired information protected by the rules that is material to the matter, unless informed consent and confirmed in writing. Okay, so again, what are we talking about here? We're talking about a big firm. Let's say they represent a client in North Carolina. You've got an office here. You're with the big firm in the South Carolina office, and you have left the firm. And they represented a client previously in a matter in North Carolina. So the question is, Are they a former client? Is it a substantially related matter? And is there information that you acquired as a result of your relationship when that client was a client of the firm? And those are the things that really have to be teased out. So let's talk about substantially related matters. What is a substantially related matter? All right, so a substantially related matter involves the same transaction or legal dispute, or there is a substantial risk that confidential factual information normally obtained in the prior representation would materially advance the client's position in the subsequent matter, and it doesn't include publicly disclosed information. So if it's in a filing that's been filed with the court, that is publicly disclosed information, and that wouldn't constitute confidential information. However, if you have access to the file, even if you've never pulled it, the fact that you have access to it potentially puts you at risk of a conflict of interest with a former client. Again, maybe it's your former firm, maybe it's your current firm. All right. So that's substantially related matters. All right, so when attorneys change firm, let's kind of dig down a little bit on this idea of attorneys changing firms. And again, you've got some tension there because you don't want to limit attorneys' opportunities for employment, changing firms, going to their own office. However, you want the clients to be protected. All right, so when attorneys change firm, the rule says it limits attorneys who change associations only when the lawyer has actual knowledge or information relating to a particular client. All right, so again, back to my situation where the office is in North Carolina, the client's in North Carolina, the files are in North Carolina. You haven't represented that client, you don't have contact with that client, you haven't worked on that file, then you're not going to be limited by the rule with regard to confidentiality to the former client. However, if it's in your office and you've done some work on that file, you potentially have now a conflict of interest, right? So again, digging down on that a little bit, the client previously represented by the former firm must be reasonably assured that the principle of loyalty to the client has not been compromised, right? So the client, we kind of fall back to that duty of loyalty to the client. The client shouldn't be in a situation saying, oh my gosh, Mary Sue Jones just left the firm and now she's working at the firm that I have something against. Is she going to divulge that any information that she learned while working for XYZ firm, right? That's the situation you don't want the client to be in. However, the rule should not be so broadly read as to preclude other persons from having reasonable choices of legal counsel. In other words, lawyers that have left the firm, the client should have the opportunity to pick the lawyer that they want, and we shouldn't read the rules so broadly as to conflict every freaking attorney that worked at that firm. Let's say again, it's a big firm, from ever representing the client. And again, the rule should not unreasonably hamper lawyers from forming new associations and taking on new clients after leaving the old association. So there's always that tension between allowing the attorney to form a new association, allowing the client to pick whatever counsel they choose, even if it's a lawyer that left the old firm, and 3, protecting the client in terms of the duty of loyalty to the client such that the client feels sufficiently protected in regard to attorney-client privilege. All right, welcome back to our ethical traps, hot button issues, and we're going to continue now talking a little bit more about conflicts of interest. We're going to dig down a little bit on the tripartite relationship in a second, but we're going to talk about, generally speaking, multiple representation. And this, again, contemplates the tripartite relationship. The tripartite relationship oftentimes or is represented by, that is where an attorney represents the insurer and the insured in a claim against the insured, right? So this often creates an uneasy alliance for the attorney because the attorney is being paid by the insurance company. However, the client is the insured / tortfeasor in the situation, and the plaintiff has filed a claim against the tortfeasor. So the defense attorney is kind of caught between the entity that's paying him, the insurance company, and the person he represents, who's the insured. So that is the tripartite relationship. And again, we're going to spend a bit more time talking in depth about that. Some of the issues that come up when we talk about the tripartite relationship and conflicts of interest is when there are coverage disputes, right? There are coverage disputes, especially if the facts establishing a lack of coverage come to the attorney in confidence, it may not be known to the insurer. So let's say it's an insurance policy that, like most insurance policies, has an intentional act exclusion. And the claim involves a tortfeasor who acted against the plaintiff, right? So in confidence with the attorney, the tortfeasor says to the attorney, well, you know what? I hated that SOB, so I hit him because I wanted to. Well, ding, 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 that's an intentional act. That may take the whole claim out of coverage. And again, you've got the attorney in a situation where he's being paid by the insurance company, right? He has learned information through a confidential attorney-client privilege. Can he now turn to the insurance company and convey that information to the insurance company such that the claim will come now outside of the coverage? Tricky situation for the attorney, right? And again, potential conflict of interest. All right, excess claims. Where the plaintiff is seeking damage that exceeds the policy limits but offers to settle within the policy limits, and the insurer doesn't want to settle. Okay, so again, we talked a little bit about the attorney's duty with regard to conveying the settlement offer to the insured, to the tortfeasor. But what happens when the tortfeasor says, heck yeah, I'll pay the claim $25,000. I don't want to be exposed to the potential $1 million judgment. And the insurance company says, no, we think we have defensible claims. We're going to take it to trial. We're going to roll the dice, so to speak. Where does the loyalty of the attorney fall with regard to that? And we'll talk a little bit more about that when it comes to when we talk about the tripartite relationship and the specific rule with regard to some states and in South Carolina. All right, settlement issues. That's a third area, potential conflict of interest, right? Often the insured is indifferent to the cost of litigation and wants to fight, right? So what happens when the insurer says, yeah, we're going to settle this claim, and the insured says, no, I want to fight because they're not paying the bills? Well, most insurance contracts have the right is delegated to the insurer, and they have the right to settle lawsuits at their discretion, irrespective of what the insured wants. But again, remember that the attorney represents the tortfeasor, the insured. That one's kind of easily resolved by the contract language within the policy, and so the attorney should really refer to that with regard to who has the right to make the determination as to settlement. Okay. Other areas of potential conflict of interest, particularly when we talk about the tripartite relationship. All right, litigation guidelines and audits. A lot of insurers have litigation guidelines and audits that require the attorney to provide information to independent auditors. What can the attorney do? Because the information is attorney-client privilege with the client, the tortfeasor, the insured. That can raise potential conflicts when the insurance company says, we want you to send X, Y, and Z to the auditor because we need to review your bill. We have very strict guidelines about what we will pay for and what we will not pay for. Well, does that create a conflict of interest for the defense attorney in that situation? And the answer is potentially yes. And again, it depends on the information conveyed. All right. What about uninsured or underinsured motorist claim? When the UM and UIM claim arise, the same insurance company may be defending the insured and the opposing party, or a John Doe claim if it's a UM coverage, right? So if it's if you've collected, let's say it's a John Doe claim, you've got a hit and run on a John Doe phantom car. So the tortfeasor is unidentified, right? So what does the plaintiff do? Well, the plaintiff has to sue basically John Doe under their own policy, and then their insurance company hires an attorney to represent John Doe against you, the insured, under your policy. And you can see how that potentially creates a conflict of interest because you're, in essence, suing your own insurance company for coverage that you are paying for, and the attorney is being paid by your insurance company to basically deny the claim or fight the claim that's your claim against your insurance company. Very convoluted. That's how it works. And again, potential conflict of interest there. All right. Another area is counterclaims, right? What happens if the insured tortfeasor wants to assert counterclaims against the opposing party and the insurer has no interest in paying the attorney to obtain recovery on behalf of these counterclaims? So the insurance company is paying the attorney to defend the action filed by the plaintiff, and the insured tortfeasor says, yeah, well, I want to sue him for X, Y, and Z. And the insurance company says, we ain't paying for that. We're only paying for the defense of the insurance claim. If you want to sue, counterclaim, and all these other assert all these other claims, you have to get your own attorney. And sometimes that's what happens is when it's counterclaims that fall outside of the coverage, the insured tortfeasor basically has to obtain their own counsel with respect to those counterclaims. That's kind of the cleanest way, and it keeps the defense attorney just focused on what they've been hired to do by the insurer, and that's to defend the claim, the insurance claim. All right. What about fraud and collusion in a claim? And again, we're talking about the tripartite relationship. So what if the attorney gets information through the attorney-client privilege that informs him or her that the plaintiff and the insured are colluding with regard to the case? Right? Is that a potential? Well, of course, the attorney cannot be a party to a criminal act. So you can't be insurance fraud or anything like that. But let's say it's lesser than that. Can the attorney then convey that information to the insurer with regard to potential collusion? And again, that may be attorney-client privilege. Can they convey it to the insurer? The attorney doesn't have to be a party to it. In other words, they don't have to condone it by continuing to represent the insured if they believe that it is illegal. However, can they convey that to the insurer? And that's where the rub comes. Not that they have to continue to represent the insured if they think there's something illegal happening, but can they convey that information to the insurer? Potential risk. All right. Another area, we talked a little bit about this, is where you have multiple insureds. The insured may have conflicting interest in their degrees of fault, or the amount of coverage may differ. So let's say it's a situation where you've got 2 or 3 multiple tortfeasors all represented by the same attorney, and you find out that there's different culpability as to each party. Probably the best practice in that respect is to separate the parties out. And the insurance company doesn't necessarily want to pay for a different attorney for every potential tortfeasor. Nonetheless, for the attorney's point of view, that's probably the cleanest, safest thing to do so that you don't have a conflict of interest. I have seen it on the other side. Let's say it's a medical malpractice case and you've got 3 partners in an OBGYN firm. The client is the plaintiff, is a patient of the practice, right? And each of the doctors has different culpability with respect to potential malpractice, right? You've got the one doctor who's, let's say, the bad actor, and the other 2 or 3, let's say, saw the patient, were negligent, but not to the extent of the bad actor, right? Well, if the insurance company, and usually there's one insurance company that represents all 3 doctors or 4 doctors in a malpractice claim, they're going to hire one defense attorney to represent the practice on the malpractice claim. But the culpability with regard to the 3 doctors is really, really different. And the other 2 doctors might want to say, hey, we want out of this thing. This is bad. And the tortfeasor, the bad actor, so to speak, says, no, I want to litigate this thing. It's my name, my reputation. I want to take it to the end. How does the attorney deal with that potential conflict of interest with regard to that? So again, probably the safest practice is to split the parties out and let them have separate representation. Oftentimes, the insurance company doesn't want to do that. They want to pay one attorney to represent all 3 docs, and it's a potential problem. Okay. All right. So we talked a little bit about the information that's conveyed in attorney-client privilege. We've talked about, what can the attorney in a tripartite relationship tell the insurer or not tell the insurer. And I think it's worth sort of stepping back a little bit and thinking about the communication. What is the information? So a communication is any expression through which a privileged person undertakes to convey information to another privileged person and any document or other record revealing such an expression. Again, very, very broad in terms of how we define a communication. You're talking about which a privileged person undertakes to convey information to another privileged person. So again, remember back to our Christmas party scenario, right? You've got a potential client who says to a privileged person who is the lawyer, hey, I'm having an affair, or I have a girlfriend, or whatever, or boyfriend. That is a communication. And so irrespective of whether money changes hands, irrespective of whether there is a fee agreement, that constitutes a communication. And that potentially creates that conflict of interest. Okay. So it's a privileged person. Who is a privileged person? Who is a privileged person, right? So privileged persons are, very simply, the client, including a prospective client. That's the person your neighbor at the Christmas party. The client's lawyer, potentially you, right? Or a prospective client. Agents of either who facilitate communications, right? If you've got an investigator who goes out and investigates a case, that person is considered privileged with respect to they are acting as your agent to gather information in regard to the case, and who facilitates communication between the parties. And agents of the lawyer who facilitate representation, right? Agents of the lawyer. Does that mean the paralegal? Yes. Does that mean the receptionist at the front? Yes. Does that mean the secretary who just files the stuff? Yes. Everyone who facilitates the representation is considered a privileged person. And I think it's inherent upon attorneys in their office when they hire somebody, when they sit down at the beginning of the hiring, it's important that they convey to their staff they are an extension of the attorney and therefore an extension of the attorney-client privilege. They cannot go home to their husband or their wife and say, oh my gosh, you won't believe who came in the law firm today, so-and-so. I see him on TV or whatever. That's privilege. Cannot do that. And it must be conveyed to the staff because they don't have the training or experience or understanding with respect to the privilege that they carry as an extension of the attorney. Okay. All right, so again, a little bit more in depth with regard to the communication. A communication is in confidence if it, at the time and in the circumstances of the communication, the communicating person reasonably believes that no one will learn the contents of the communication except a privileged person or another person with whom the communications are protected under a similar privilege. All right, restatement third, the law governing lawyers. So again, let's go back to our Christmas party, right? Your neighbor grabs you by the sleeve and pulls you over to the corner and says, oh my gosh, you don't believe I have a girlfriend and blah, 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 right? Do they have an expectation that that information is going to reasonably believes that no one will learn the contents of the communication? The answer is yes. That's why they dragged you over to the corner. If they stand up on the piano and say, oh my God, I got a girlfriend, not privileged communication. Obviously, the difference between the two. So again, when that neighbor pulls you to the corner and says, let me tell you something, that becomes privileged communication. All right. We talked a little bit about the tripartite relationship. We're going to talk a little bit more about that, but it's important to understand in your jurisdiction, states have different rules with regard to the duty of loyalty owed to the client, right? Some states are a two-client rule. And the two-client rule says that the attorney must withdraw from representation and perhaps further, depending on the confidentiality rule that applies in the jurisdiction, the lawyer may be authorized to reveal the insured's confidences to prevent a crime or fraud. All right, so we're talking about, again, back to collusion or fraud. When you have a two-client model, the attorney has a duty to both clients, the insured and the insurer. And in that situation, the attorney has to withdraw from representing the insured, but they can convey information to the insurer under a two-client model. And that allows the attorney to kind of split their brain and represent two clients at the same time, even though their interest may not be the same at all times, right? There is such a thing as a modified two-client rule, right? The modified two-client rule says the defense attorney should continue to represent without revealing the insured's confidences to the insurer, right? So it allows you to represent both parties, but you don't have to divulge information against the insured in that situation. The difficulty with that is that it's confusing to whom do I owe a duty of loyalty, and potentially puts the lawyer in a really bad situation. And it may not provide adequate protection for the insured's interests. In other words, the attorney is kind of splitting their brain, representing the insurer and the insured, and that is very confusing and potentially creates huge conflicts of interest because you don't have really a duty to either and you have a duty to both. Very complicated, very confusing. All right. The third kind of provision is a one-client model. And in South Carolina, that is what we have. We have a one-client model. All right. The one-client model says the counsel acts to further the interests of the insured client, subject to ethical and legal constraints. In other words, you cannot collude with the client or help the client or assist the client in committing fraud. And that's Rule 1.2. But the duty of loyalty of the attorney is to the insured. Even though they're getting paid by the insurer, the duty is to the client, the insured, the tortfeasor. And I cannot stress that enough because young defense attorneys often get in a situation where they want the repeat business. They have a relationship with the insurer. They want to continue to serve that insurer because, again, it generates a lot of business for that young attorney. But the duty is owed to the client, to the insured, to the tortfeasor, and the tortfeasor only. And we are a one-client model state. South Carolina is. Okay. So we talked a little bit about the tripartite relationship, policyholder, insurance company, defense counsel. And the most common failing of defense attorneys is that one-client model understanding, and that is that the protecting the interests of the insured over the insurer. Because again, there's stress, pressure to continue that relationship with the insurer, to serve the insurer so that they will have continued business, repeat business, that you have a good relationship with that insurer. So you want to serve that insurer in such a way that they'll continue to hire you. However, again, the duty, at least in South Carolina, is to the insured, to the tortfeasor. And the most common failing with defense counsel is not protecting the interests of the insured. Not conveying the settlement offer, not understanding that while the insurer may want to litigate the case, it is in the insured's best interest to settle the case and let the insured tortfeasor move on, not expose them to potential excess judgment, not expose them to years of litigation. And I think that defense attorneys have to be really cognizant of that because that's a potential problem. Okay. All right. And again, the law in South Carolina comes from a case called Twin City Fire, and it's cited in the materials. But it says unequivocally, here's what it says. A lawyer hired by an insurer to represent an insured owes an unqualified duty of loyalty to the insured and must act at all times to protect the interests of the insured. Again, no gray with regard to this. Very, very bright line, at least in South Carolina. And again, that comes from a case. It's a federal case, but it is citing South Carolina law, and that's Twin City, and that's in your materials. Unqualified duty of loyalty to the client, to the insured. Unqualified. Again, no gray area. Really, really bright line. All right. So just following up, preserving attorney-client privilege. The lawyer shall not reveal information relating to representation of a client unless the client gives informed consent. Okay, I included this because I think oftentimes attorneys, particularly young attorneys, don't understand that the privilege belongs to the client. It's not your privilege. It's not your privilege to assert. It is the client's privilege, and the client has to give informed consent about waiving the privilege. I see a lot of attorneys who use it as a shield. It is not the client's privilege. I mean, it is not the attorney's privilege. It is the client's privilege. And so in order to assert it, they have to understand the client and inform the client, hey, I've been subpoenaed to this. I've been requested to provide these documents. I think it's privilege. It's your privilege to assert. Do you want me to assert it? And again, that goes back to consultation with the client, having the client understand the means necessary to accomplish the attorney's and the client's goals with regard to the case. Okay, so I think attorneys use it as a shield when in fact it is a privilege that belongs to the client. All right. Attorney-client privilege may be invoked with respect to communication made between privileged persons in confidence for the purposes of obtaining or providing legal assistance for the client. All right. So again, let's talk about the Christmas party, right? Is it a communication? Well, we've talked about that, where a person has a reasonable belief that it is a private communication between privileged persons, that's the client, potential client, and the attorney, in confidence. And again, that sort of goes back to that idea of reasonableness, that it is in confidence for the purposes of obtaining or providing legal assistance to the client, right? So the guy says, hey, I have a girlfriend, should I clean out my bank account? That's asking for legal advice. Even if you don't give it, it's still privilege. Again, you can't go home from the party and tell your husband, oh my God, you won't believe what John told me at the party tonight. That's privilege, irrespective, as I've said many times, irrespective of fee agreement, irrespective of a formal agreement, irrespective of any money changing hands, irrespective of your intent to represent that person. You have now entered attorney-client relationship because of the nature of the information conveyed. Okay. Steps to avoid trouble. So this is kind of the wrap up in terms of steps to avoid trouble. First thing is clearly identify the parties in their interest. Again, we talked about former clients, current clients, potential clients. Very important the attorney identify the parties and the interests of the parties, because in terms of avoiding the conflict, it's very important to be clear about who wants what the interests are. Recognize when the interests of the insurer and the insured diverge. Again, in South Carolina, it is a one-client model. And when those interests start to diverge, the attorney needs to be aware of the situation. And I say paper the file. Be sure that you have documented in there, hey, my duty of loyalty is to the client. However, the insurer wants this, this, and this. And that's a potential problem. Such as when a settlement demand exceeds the policy limits or a coverage question arises. 2 examples. Obtain consent as necessary in writing. I don't think you can ever make a mistake by getting informed consent in writing for anything, whether it is representation of a potential a new client against a former client, or potential overlap of interests. Document the file, paper the file, put it in writing. If you think your client might need to be informed and consent to it, get it in writing. Take appropriate ethical action, such as informing insured and insurer to obtain independent counsel with regard to issues where a conflict exists. Okay, so where you see that potential risk, as we talked about, you got 3 doctors in a practice. You are potentially in a situation where now you are representing the bad actor, tortfeasor, as well as these kind of guys that really didn't do anything wrong. Recognize that and say, hey, I think we need additional counsel to represent their interest, or whatever. Protect yourself and recognize that situation. All right. Confidentiality. Confidentiality is the fundamental element of attorney-client relationship. The rules prohibit disclosure of any info relating to the representation unless permitted by an exception. All right, and again, that exception might be fraud, criminal act, things like that. But it is the client's privilege, and it is really, really important. That kind of wraps up the material. There is one area that I don't have in the material that I do want to talk about, and this is kind of an emerging area with the commission and the ABA. So the ABA has now developed a section, I guess, with regard to this. And that is when you have firms, is the transition of firms when a partner dies, or when a partner is disbarred, or when a partner becomes unable to practice. For example, they're in a coma, something. So the not new rule, but the evolving rule with regard to that is that firms should have in place some plan with respect to when a partner, or when a firm, a principal in a firm, maybe not a partner, but a principal in a firm becomes either dies, becomes unavailable through some means, or retires, decides not to practice anymore. What happens to the transition of the firm? And the ABA is focused on trying to encourage law firms to have a plan of succession. a plan of succession. So it's really, really important. I know with our firm, we have started to talk about that, a plan of succession. We have a principal who manages the firm, and what happens if something happens to him? How are we going to deal with that? How are we, and more importantly, how are we going to protect our clients with respect to that? The rules of ethics prohibit a law firm passing to a non-lawyer. So let's say a firm, a husband has a wife who's not a lawyer, right? And the husband dies. The law firm cannot pass to his wife through a will or through intestate succession because she is not a licensed lawyer. So again, this plan of succession, this needs to be something that firms consider, start to put in writing, and start to consider. Okay. Any questions, guys? No? All right. Well, thank you again for being here today. I hope this has been informative. My information's on the last slide or the last page and if you have any questions, feel free to email me. I'm available, and I don't have a phone number on here because my phone at the office doesn't get answered. But you can always email me, and I'm always available, and I'm happy to help. So good luck, and again, thank you for being here.